stage forthwith. I declare the House in Committee for consideration of the Employment Relations Amendment Bill number 2. Mr. Chairman.
Mr. Speaker. Members, the House is in committee for the Employment Relations Amendment Bill number 2 and the question is that Part 1 stand part. These are clauses 4 to 38 and Schedule 1. I call the Honourable Trevor Mallor.
Mr. Chairman, I think it's interesting that for a bill that is this important and so vital to the economy, that we have sitting in the chair a junior minister from outside the cabinet, someone with very little experience in this area, and one for whom there's so little respect one for whom there's so little respect that the officials have not even turned up to support him. Mr. Speaker, I think it is a sad state of affairs when the Minister of Labour herself, not the sharpest pencil on the National Party box, is being replaced by Maurice Williamson, who I think it's fair to say, while he has opinions on lots of things, wouldn't claim to be an expert in the labour relations area. He does pretty well on statistics, but
only 9 to 5.
His talent is relatively limited. Mr. Chairman, this is the first substantive part of this bill. There would be some more substantive parts as time goes on and the extra parts start hitting here. But the Labour Party has as a starter tabled a set of amendments which we will be working through in order to attempt to make this legislation, I won't say palatable, but sorry. What happened there? That's the one with the brain of Paul Quinn and the voice of Judy Keel. Mr. Speaker. No. Well, I think I'm not quite sure what she said. Good. Mr. Speaker, what we have here are a number of amendments which are designed to make a bill which can never be palatable as part of legislation which itself is unpalatable, slightly better than would otherwise be the case. And what we've done here is get an attempt to get the support of the Maori Party and of the Greens, some amendments which are reasonable. You know, they're not radical. They're not. Most of them don't have the sort of substance which is necessary to turn the legislation around, but to make it slightly better. The first one, for example, is would put in a clause which would require the employer to provide access to information about a decision to dismiss an employee. And that, to me, just seems a pretty basic human right. It's part of the fairness that is ingrained in New Zealanders about their relationships at work. If you're getting the sack, then you have a right to information about that decision. And Mr. Speaker, there's another one around the 90-day trial cannot be advertised as a condition of employment, and I think that's pretty important, because at that stage it shows a absolute lack of openness on the part of the employer as to whether or not that will be a condition. Although one of the things I say to my colleagues is that I think we will get to the point at some stage of good employers doing the opposite. I think what we will find is that over a period of time we will find good employers putting in their ads, we do not use the 90-day trial procedures because we trust our own ability to recruit and we trust the processes which flow. Sorry? Well, no, good, that's exactly right. The good employers, the member, Michael Woodcock, has just accepted that good employers will not use this system. And I think that's something that is great.
I think I can anticipate the point of order, and that is that we use correct names, and the member did not say Woodhouse. So in the future, could I ask him to just pay a little more attention to that?
I apologise. I think members on this side understand that members opposite come and go, and I get them mixed up over a period of time. And while a member is considerably more talented than average on that side, that is not a particularly high test. But I do acknowledge Mr. Woodhouse, who I've sat on a committee with, who regularly supplies me with bottles of wine as his team loses to Wellington-based teams. And I do acknowledge his name. But I do, Mr. Chairman.
Honourable Trevor Mallon.
Mr. Chairman, I do want to emphasise what Mr. Woodhouse did say, and that is that good employers will not use the system. And I go one step further. I think that good employers will make it clear that they're not using the system in order to attract better employees into their workplaces, and to give people some security. Because as I indicated earlier, if someone is a talented person who is being well paid, who has a family to support and maybe a mortgage, they don't want to go into a situation, even if it's worth a few $1,000s a year more, where they could be sacked next week and without a reason, and not have the income necessary to support their families. There is another area of amendment, Mr. Speaker, whereby we are suggesting that unjustified dismissal and personal grievance remedies may be sought where good faith has been breached. And I agree with Michael Woodhouse that most employers are good employers. No, the vast majority of them are good, but, you know, there are some who aren't. There are some who are dogs, who self-respecting fleas would not sit on. And Mr. Speaker, Tohanare used to be on the workers' side against those. Well, no, there have been a few sacked since Tohanare. Tohanare in those days used to go toe-to-toe with employers. He used to line up in that way. In fact, he used to go toe-to-toe with union officials too, except some of them he just hit from behind, Mr. Speaker, with bottles. Mr. Speaker, Tohanare knows that it is important to have procedures where there is unjustified dismissal and where good faith has been breached. And what's good faith? That's exactly the point. For some employers, there is no good faith, and when that is the case, Mr. Speaker, there must be a process for their employees. Mr. Speaker. Mr. Speaker, I understand Matt is not very well. I think I want to say no more than Matt is not very well. And Mr. Speaker, that is something that we all know. Mr. Speaker, there are amendments around communication during collective bargaining, because what this bill does not require good faith to occur on the part of employers. What this bill does is take away requirements for good faith on the part of employers during collective bargaining. And I just say to members opposite, what sort of a country do they want to live in? What sort of New Zealand do they want? Do they want one where we can work together as wage and salary earners and employers? Or do they want to go back to the Alan Peachy approach, the class war, the Marxism? In fact, I think I was trying to work out the analysis that Alan Peachy was giving in relation to this particular clause when he was speaking in the House, and actually it was a Marxist analogy. I mean, his analysis was someone who I think had spent quite a lot of time looking at Das Kapital and not enough time looking at the way